When a loved one has died, oftentimes what family members find is that the bank accounts of the deceased person are now frozen. So then what happens is that they go in with their durable power of attorney that they had and are surprised and dismayed to learn that that durable power of attorney is no longer in effect. So even though they were appointed under the power of attorney to manage the person's finances and bank accounts, the durable power of attorney basically dies when the person who signed it, when the principal dies. So what you're left with then is a frozen account and a lot of frustration, and people simply don't know what to do at that time. So there are ways to avoid these frozen accounts. What can be done is that the person who is the agent under the durable power of attorney, they can be set up as a co-owner of the account. And then when the person dies, the co-owner, the surviving co-owner, then has access to the funds. So this can be a very effective strategy to make sure that the account isn't frozen and that there's immediate access. Now, there's a lot of reasons why not to make people co-owners. That is covered in a different discussion. Another probably safer way to avoid frozen accounts and have access to the funds is to have that bank account prior to the person's death be set up to pay on death. And if it pays on death, that bank account can pay on death to whomever was to receive it, to the one child, two child, three children, whatever the estate plan was. So a pay on death provision for a bank account sometimes is a very effective strategy to avoid frozen accounts, perhaps even to avoid a probate. Now, whether or not the best estate plan is to avoid a probate, again, that's a discussion for another time.